Hey everybody, Brent Rice, coreVISION Financial Group, coming to you today with another episode in our series on financial topics. Hey, please go to our YouTube page and subscribe so you're notified when we post new videos. Today I'm joined by Grant Reeves, and our topic today is going to be beneficiary designation. What we're going to talk about is, when it's appropriate to designate a beneficiary, when you need to worry about that, when you don't need to worry about that. How you doing today, Grant?
All right, how you doing?
Fantastic. Thanks for joining us. Appreciate it.
Yep.
This is a very important topic. It's something that we run into all the time to where people, haven't designated a beneficiary, haven't thought about it, or don't understand, what's the benefits of it or when it shouldn't apply. So why don't you introduce yourself real quick, give us a little bit of background on who Grant Reeves is and what Grant Reeves does.
I am the Chief Compliance Officer here at coreVISION and have some advisory clients as well, but then I'm also a practicing attorney. Quite a bit of my practice is in estate planning, so this is a topic that comes up quite a bit as far as the beneficiary designations and how they tie in with estate planning.
So you and I have had several discussions about beneficiaries and when that designation helps, and so we've run into this all the time. When we're setting up accounts, we're asking for beneficiaries. When we're reviewing outside accounts, we're like asking about and looking for, hey, has this got a designated beneficiary on it? So real quick, let's talk about what is a beneficiary, what are the types of beneficiaries, just kind of, what account types, have beneficiaries, need beneficiaries, that type of thing.
The beneficiary designations are very important. They actually come in line in front of other estate planning tools usually. So it may seem like a spur of the moment decision where you go in and you check a little box on the form when you're opening an account and you may never think about it again.
For sure.
But people, what they may not realize is that will actually come in line before their estate plan. So they may have spent hours working on their estate plan with their attorney, and then they go in and check this little box and everything passes through that beneficiary designation, and it may not have been what they intended to do as far as going along with that estate plan. So beneficiary designations certainly have their place in simplifying things. They have a huge place in qualified money because there's tax benefits on retirement accounts and things like that, 401k, IRA. There are tax benefits to naming a beneficiary and having those pass through that beneficiary designation. But it's something you really do need to be conscious of and think through that decision, make sure it agrees with your estate plan and your intentions, make sure that they've given, the bank has given you the right form or the financial institution, that they've given you the correct form that matches up with what you had intended to do.
So when you talk about what you intended to do, let's talk about that real quick, because recently we had a situation where a parent, intended to make a child beneficiary, made them a co-owner, or vice versa, wanted to make them a co-owner, made them a beneficiary. Can you real quick just talk about what's the significance of it being a beneficiary versus a co-owner?
Sure. This is another area where I've seen mistakes as well. I think in my case, somebody went into a bank and I think there was a miscommunication and they got the wrong form. They put the child as a joint owner on the account, and if that's a child's a joint owner, that's a child's asset, particularly for purposes of creditors. A creditor likely is going to attempt to go after that. If the child gets in financial trouble, the child could potentially walk in and clean out the account if that's what they wanted to do. So that you want to be really careful if that's actually what you intended a joint account. And usually there's going to be a better way to do that if you're trying to give either a benefit to the child after you pass, which that would be a pay on death, or a beneficiary designation that you would put on an account. Or if you're just wanting the child to go on as a signatory, you may want to talk to that institution about some sort of a power of attorney arrangement, or putting them on as a signatory where they don't actually have ownership of those funds. They just have the ability to sign and help you conduct your business as you need to, particularly as you get older. That may become important.
Yeah, I think understanding the differences, we just added POA to the conversation of, beneficiary and co-owner. Each of them are significantly different, and, there's rules that apply to each of them that, as a POA, you can help make decisions, you can, they can talk to you about it, but it's not your asset, like if you were a co-owner, right? It's not giving them beneficiary of transfer on death, it's none, so it's all about specifically to your situation, what you're trying to do,
right?
And what you want done, but understanding those to make sure you make that right. Because people I think want to do POA and end up doing co-owner, because I can see how that happens very quickly in a conversation, especially if you're talking about, an elderly parent who doesn't quite understand that. They just say, yeah, just put their name on it. That'll save me the headache of having to go to the bank and do all this and that. But then, like you said, then that makes them a co-owner and their asset. If something was to happen to where, like you said, a creditor or a lawsuit or something, that gets mixed up in there, and that's not the intent. Or that then that person has the ability to, like you said, potentially go in and use those funds for a reason the other co-owner, had not set those funds aside. So, there's a lot of pros and cons to each of those, but making sure you understand the difference between the three of them and making sure that that's what you were trying to do. Because like you said, in those conversations, like it's real easy, you can get the wrong form, the person at the bank or say it's an older parent, it's just gets them just twisted in their mind real quick. Next thing you know, they were wanting to do a beneficiary and then labeling somebody as a co-owner, and then the rules are completely different.
Correct.
So let's talk about some of the benefits of adding a beneficiary as far as probate avoidance. You talked briefly about tax avoidance and some issues there that they can help with. Can you just touch on that just a little bit as far as probate, what it is, what we're trying to avoid, what naming a beneficiary will avoid in probate, or just how does that help?
So naming beneficiaries are a great tool for efficiency in estate administration. I practice in Indiana, and in Indiana you have probate assets. And probate assets are the things that have to go into court. And what we have is if you're under $100,000 in Indiana in those probate assets, you don't have to go to court to open an estate. And things like beneficiary designations, pay on death, fall outside of that. So they can transfer automatically. Simply, you set up your beneficiary designation. Often your heir will just have to take in a death certificate, and they will be able to get that administered and get that beneficiary designation on there without having to go open an estate and do that, deal with the delay and the potential expense of that. At times you may want that estate to be opened for different reasons, but if it's a tool where you simply want an asset to pass to a specific heir, the beneficiary designation is a simple way to do that usually. Another circumstance where the beneficiary designation come into play is in, and I mentioned this briefly earlier, are in what we call qualified accounts that have special tax treatment, usually an IRA, 401k, those types of accounts. Under the current law, there is a 10-year period usually to stretch those assets out for your heirs where they can wind that down. Over that 10-year period, they will have to gradually withdraw assets out of there. One of the key benefits to that is it will spread the tax obligation. If it still has taxes due on it, if it's a traditional account, your heir is going to be able to spread that out to kind of align. If they have ups and downs in incomes, they can balance that out. If there's no beneficiary, there's high odds, particularly if it's not a spouse, that it may dump into the estate, and then that may trigger that being all taxable at once. Even if it's a Roth account on a beneficiary designation, you may be able to just let the money grow tax-free for an additional 10 years that you would not have had if there was no beneficiary designation on it. And then certainly on life insurance policies, usually they have to have a beneficiary of some type. And generally, that's going to be the best way to have those life insurance policies passed as well, is to make sure that those have those named specific beneficiaries.
And designating beneficiaries is a way to give the original owner flexibility and control over where that money goes, right? Because making somebody a co-owner, then it becomes muddied up, as opposed to if it's a beneficiary, you can just change the beneficiary.
Right. And another thing people don't realize about the co-ownership situation, frequently that would be a co-ownership with a survivorship right. That's generally going to be your default at a particular bank or financial institution. And when you pass, that asset literally becomes that other person's account. It becomes solely theirs. And I've had that situation occur as well, where the party named one child as a co-owner. I'm assuming it was before ease of having that child help them with certain situations. Their will said all of their children were to divide all of the assets equally. Almost all of the assets in the entire estate were in that joint account. Child refused to turn anything over, and I was stuck. There wasn't really anything I could do, and just off of that one form, the rest of the family had basically been disinherited. Even though that was clearly not the intent, that was the way the priority of the law worked, and there was no way around it.
Yeah, so co-owner, literally transfer on death, it becomes that, and they're at no obligation to split those assets
Correct.
up.
I have had some families where somebody's realized it and they're like, okay, yeah, this is not what mom and dad intended. I'm going to share this with my siblings. But I've had some where they're just like, tough. That's the way it goes, and we were stuck.
For sure. Any other topics specific to beneficiaries you want to cover before we wrap this up? I think we've covered most of the items we wanted to. I mean, we have here clarity and dispute prevention.
The only other thing where sometimes it will come up, and one thing to be aware of, is when you're naming beneficiaries, often you name a primary beneficiary. Frequently that's going to be a spouse or somebody within your generation. If you're naming your children when your children are still minors, you need to be cautious about how you do that. If you name them as the contingent beneficiary, that asset, or as any beneficiary, if they're still a minor, that asset is technically theirs. It would go directly to them, and there are things you can do to fix that situation so that you don't have a 10-year-old walking around with a huge life insurance policy or something like that. But frequently, the best way to handle that situation is going to be to work with your legal advisor and designate some sort of a trust vehicle or a transfer to minor vehicle that's going to automatically have rules and restrictions on it so that child's not directly inheriting it. That's another thing we'll see mix-ups in that. We were able to correct the situation when a child inherited life insurance, but it was a lot more hoops to jump through. We had to go through a guardianship proceedings and some things like that. Whereas if it just was updated on the beneficiary, it would have taken care of it to begin with.
Yeah, that's a big deal. You don't want to, not that a 10-year-old wouldn't love to have a huge life insurance payout, but it may not be best for everybody involved.
And one final thing to touch on is if you have a major life event, pull those beneficiaries out and look at them. One issue where I've had this come up was in a divorce situation. The state law on wills will often knock out an ex-spouse and just assume that was not the intent if it's in a last will and testament. Those state laws generally don't apply to beneficiary designations. So if you don't update that, there's a chance of having an ex-spouse inherit something that you did not intend. And unfortunately, I had this happen in another state where there was the divorce was finalized and the poor person passed away quickly thereafter and had not updated the beneficiary on that life insurance. And I in that particular policy, I could not determine any way around it, and it ended up going to the ex-spouse, even though everyone was pretty confident that's not what the person intended at that point.
Yeah, updating beneficiaries is another very important thing. Life events, births, deaths, divorce, marriage, all of those type of things, when they happen, you need to take a look and say, okay, how does that impact this? How would I want that changed? That's a great point. Life events, definitely need to review beneficiaries at life events to make sure that now it reflects the current situation. Well, Grant, we appreciate you spending some time with us this morning to talk about this very important topic.
Yeah, certainly. Thank you for having me.
Again, Brett Rice, Grant Reeves with coreVISION Financial Group. Thanks for spending some time with us. Again, go to our YouTube page, subscribe, be notified when we post a new video. Again, thanks for spending some time with us. Contact information at the end of the video. Reach out if you ever have any questions. Thank you.